Good evening, everyone, and welcome to the next webinar in the Downtown Law and Business series for the Ross Parsons Centre for Commercial, Corporate and Taxation Law here at Sydney Law School. My name is Jason Harris. I'm Professor of Corporate Law at Sydney Law School, and I'm also the Director of the Ross Parsons Centre. The purpose of these webinars are to share some of the interesting and exciting research that some of our corporate law and commercial law academics are doing around Australia. And the focus of tonight's session is to consider the issue of directors' liability for insolvent trading. Now, of course, in Australia, we've had an insolvent trading provision for several decades. It's both a civil liability provision and potentially a criminal liability provision. And it's a provision which has been much reviewed, much critiqued, and of course, many of the practitioners online tonight would be aware that we've had the introduction of a safe harbour defence for our insolvent trading provision. The focus of tonight's session, though, isn't just Australia's insolvent trading provision. We're going to be revisiting Australia's insolvent trading by looking through the lens of New Zealand's reckless trading regime. Now, New Zealand has multiple provisions in their Companies Act 1993 that address the risk of what we would consider to be insolvent trading. And there's been a very significant recent Supreme Court case in New Zealand, and many of you would know that the Supreme Court of New Zealand is the apex court in New Zealand, on appeal up from the Court of Appeal and initially in the High Court in New Zealand. So tonight we're going to be going through this recent case. It's a case called Yan and Manziel, and joining me in the discussion tonight two insolvency experts. We have Mark Willard, who's an Associate Professor of Law at Southern Cross University and also a former Legal Director of ARETA and former insolvency lawyer. We also have Natasha McHatton, who's an insolvency lawyer and consultant, and Natasha's got considerable experience working in major law firms and is also a former Legal Director of ARETA. The format tonight is we're going to go through the case. Usually, for those of you who have attended a few of these sessions, usually we have a presentation and then a comment at the end and then general questions and answer session. Tonight, we wanted to have more of a discussion about some of the issues that the Manziel case involves. And so the discussion is going to be led by Mark with comment from Natasha along the way. But if you do have any questions, you can post them up in the Q&A function on your toolbar. So we will leave about 10 minutes or so at the end of the discussion for some general questions and answers. This session, of course, is being recorded, and we'll send a copy of the recording to all of the registered attendees, along with a copy of the slides for tonight. So I'll now hand over to Mark.
Thanks very much, Jason, and thank you for the opportunity to be part of this webinar. Thank you, Natasha, as well. It's great to be here with both of you and all our participants to discuss what I think is a very interesting case that's come out of New Zealand this year. And for us academic types, it's always interesting to see how other jurisdictions and their laws try to deal with the same sorts of issues and strike the right balance on issues that we also grapple with here in Australia. And of course, in that sense, we're talking about laws that try to strike a balance between reasonable risk-taking and entrepreneurship and use of the corporate form on the one hand, and on the other hand, abuse of the corporate form and insolvent trading and not properly taking account of creditors' interests. So really interesting issue. We're going to try and keep it relatively informal, and Natasha, I know, is going to pipe up as and when she wants to add some perspectives, as she's also gone through the case in some detail, and we've had some discussions about it before the webinar tonight. So it's going to be relatively interactive and conversational. The agenda of sorts is there on the slide. We're going to just quickly take you through the provisions. I think that's really just to set the scene. I'm not going to obviously read them out, but I think it's helpful just to put the relevant provisions from the New Zealand legislation up on the slide for you, just so you can get some context, because they were obviously at the heart of the case that we're going to be talking about, the recent decision of the New Zealand Supreme Court in Yan and Manziel Property and Construction Limited. Given we've only got an hour, I'm going to go straight to the New Zealand Supreme Court decision. I'm not apologies if this is a disappointment for some of you. I'm not going to take you through what happened down below and what happened at the Court of Appeal and the relevant submissions. I'm just going to go straight to the key takeaways from the Supreme Court's decision, which will then lead into what I hope will be an interesting discussion about how these statutory duties to prevent reckless trading in New Zealand compare with our statutory duties to prevent insolvent trading in Australia. So using a bit of a sporting metaphor, I'm just going to add my perspectives on where I think Australia might have something to learn from New Zealand and vice versa, and as will Natasha. Natasha's then, I think, going to lead a bit of a discussion in the second half on general law duties to consider creditors' interests. We'll have a chat about what the recent UK Supreme Court decision in Sequana can tell us, how that fits into the mix in terms of the issues we're talking about tonight. And then we'll cap it off with a discussion of potential law reform issues in Australia and New Zealand. And of course, as Jason mentioned, a general discussion. So that's the
plan.
That's the agenda.
Before Mark sort of launches into that more detailed discussion of Mainzeal, I thought there was just a couple of things that, from my perspective, were quite useful to note about the Mainzeal decision and why I found it interesting coming at it with the perspective of what we can potentially learn from that in the context of the Australian journey with law reform. And what I really liked about, again, just focusing on the Supreme Court decision, it is a very detailed and comprehensive judgment that assesses the New Zealand provisions, which Mark will run through. And they look at it from the perspective of, and I think there's a quote here that says, the extent to which and how these particular provisions provide protection to creditors. And it's looked at through the context of a fact scenario that is quite interesting. I think it's sometimes potentially a little bit surprising in the way it unfolds, but it's also a very relatable set of facts, I think, in terms of the sorts of things and the ways in which financial distress can manifest itself, particularly with corporate groups where there is overseas parent companies. And personally, what I really focused on in the judgment was looking at the section where the Supreme Court examined the legal context and history of the New Zealand provisions. And I think that's a really useful reference point for us to be looking at when we're assessing what lessons we can potentially learn from a reform perspective. So one of the things, there's just a little quote I wanted to note out of the Supreme Court decision in Mainzeal, which I think is really useful as we start to look at what the decision involved and what they reached. And the judgment spends a lot of time looking at the underlying policy considerations for these particular provisions and also the potential for tension between policy considerations. And the court acknowledges at paragraph 113 of the judgment this potential tension in what they say as, quote, the desirability of encouraging the taking of business risk and associated with that, allowing directors a wide discretion in matters of business judgment as against providing protection for creditors. And I think that's a really useful summary, as Mark indicated earlier, in the sense of that's really the challenge that we want to try and achieve and the balance that we want to get right as we are sort of at this point in time, given various other things going on in the Australian regime at the moment. How and what do we need to be talking about and looking at in order to get that balance right? And I think that's just a really useful kind of quote to bear in mind as Mark looks at and focuses on the more of the detail of the decision itself.
Thanks, Natasha. No, they're very well made comments. And what I would add to that is your point about the judgment looking at the underlying policy considerations in not only the provisions as they stand today, but the way they evolved from previous iterations of legislation, I think is a point that's always worth bearing in mind with our current reform agenda. And you've summarised very, very well the balance that we're trying to strike with this particular issue. But I think it's a point that cuts across all of corporate insolvency reform and the recent PJC inquiry report. It's important that we have this debate about what we want from our system. The comments often made about how our laws are pancaked to piecemeal. It's a band-aid, been a band-aid operation for some time. And I do think we've kind of sort of lost sight at times of what exactly we want to achieve, which I think hopefully will be something that will be a focus of the comprehensive review when it comes to pass. So I think one reason as well, I think the point you're making is a good one. So going into just to set the scene, the provisions themselves, and I'll come back to some of the key distinctions between the New Zealand provisions and the Australian provisions later. So I'm not going to speak too much about the comparative aspects now. It's just to set the scene. The two key provisions which were at the heart of the Mainzeal case were Section 135, which is entitled Reckless Trading, provides that a director of a company must not agree to or cause or allow the business of the company to be carried on in a manner likely to create a substantial risk of serious loss to the company's creditors. Then we have Section 136 in the Companies Act of New Zealand, which provides that a director of a company must not agree to the company incurring an obligation unless the director believes at that time on reasonable grounds that the company will be able to perform the obligation when it is required to do so. Now, those two provisions were really the key provisions which were the subject of alleged breaches of duties by the Mainzeal directors. Of some relevance as well are those two provisions there on the slide, which are similar to what we see in our Corporations Act, the duty of directors to act in good faith and in the best interests of their company, and Section 137, the director's duty of care to exercise the care, diligence and skill that a reasonable director would exercise in the same circumstances, taking into account those matters there on the slide. And the Supreme Court observed in the judgment that the director's conduct when focusing on allegations of breaches of sections 135 and 136 will be assessed according to the knowledge that a director should have and the awareness that a director should have, assuming they've fulfilled their duty of care under section 137. So that's sort of where the duty of care and diligence fits into the picture. I think it's a timely observation or reflection of our legislation in Australia that I cannot put up the insolvent trading statutory duty or the safe harbour on a slide like I can from the New Zealand provisions. So what I have decided to do is just again to set the scene, and many of you would already be familiar with it, just a reminder of a recap of what our insolvent trading duty is in Australia, taken from the review of the Insolvent Trading Safe Harbour report from November 2021. I'm not going to read that out. I think we're all familiar with it. And of course, now layered on that is the safe harbour carve-out or defence, where directors are developing one or more courses of action that are reasonably likely to lead to a better outcome for the company. A better outcome being defined as an outcome that is better for the company than the immediate appointment of an administrator or liquidator of the company. So we do have, I think, there an interesting point of comparison, just how complex and lengthy our provisions are in Australia compared to the New Zealand provisions. Something perhaps to bear in mind. We're going to hold that thought for the discussion towards the end, because I don't necessarily think it means that the New Zealand provisions do any worse a job for their brevity. So getting to the facts of Mainzeal, it was a large New Zealand construction company that went into receivership and liquidation in February 2013. Mainzeal traded whilst balance sheet insolvent for many years. I'll come back to that point shortly, noting, of course, that we have a cash flow test for insolvency in Australia that's part of the statutory duty to prevent insolvent trading. I'll come back to that, as I said, shortly. The liquidators, as I said, sued the Mainzeal directors for breach of those statutory duties. And I think in the second paragraph of the judgment, it's a good snapshot of effectively the scenario which came before the court. From 2008, Mainzeal generated at best limited operating profits, but more usually losses. In permitting Mainzeal to continue to trade in those circumstances, the directors relied substantially on assurances of support from associated companies. Central focus of the appeal was the directors' reliance on those assurances of support as a primary basis for continued trading. Now that's an issue I think many of the participants, attendees tonight, would be somewhat familiar with. Not an uncommon issue that arises in these sorts of cases, relying on assurances of support from related parties or other group entities. Money, I'm not, of course, going to go through, it's a 140-odd page judgment. I'm not going to go through all the details, really just trying to identify the key points. Again, a fact that's not uncommon in these sorts of cases, money was extracted from Mainzeal for the benefit of its ultimate parent. Mainzeal continued to provide funds to other companies in the wider group, and the court noted that was a pattern that only changed from May 2012 onwards, from which point in time there was a net flow of funds into Mainzeal from other group entities. The loans to related companies were practically irrecoverable, so Mainzeal was balance sheet insolvent from 2005, so traded whilst balance sheet insolvent for a significant period of time, many years. Directors relied on assurances of support that were not enforceable, so no contractually binding commitments. And again, I put a quote there from paragraph 36, because I think it's key, fundamental to the willingness of the directors to continue to trade, notwithstanding the poor trading results and the persistent balance sheet insolvency, was their understanding that Mr. Yan, who was a director and representative of a shareholder, and the group of companies would stand behind Mainzeal if required. Ultimately, the New Zealand Supreme Court determined that the directors had breached their duties under both sections 135 and 136. 135, of course, remembering that's the reckless trading provision, which addresses a manner of trading or agreeing to allow a company to be traded in a particular manner, which causes substantial risk of serious loss to creditors. The court concluded that as to solvency and support, the directors did not press their concerns to a logical conclusion. They never received an unequivocal commitment or refusal of such a commitment to capitalise the company or otherwise address its insolvency. And so by that, and again, I don't have the time to go through blow by blow the relevant parts of the judgment, which take you through the chronology, but there were directors at times, and Natasha can pipe in if you want to, who identified the issues and concerns, but then sort of effectively let the matter drift and didn't bring it to a conclusion by, as the court said, ensuring that there's some sort of binding commitment that would address the problem. Now, in respect of section 136, which is that debt-specific duty in terms of incurring obligations, that I'll just go back to the slide to remind us of that section. The director of a company not agreeing to the company incurring an obligation unless the director believes on reasonable grounds the company will be able to perform the obligation when it's required to do so. The court on that score held that from the relevant dates, and of course, because it's a debt-specific duty, you've got to look at various obligations that were incurred at various times. I'll come back to that point in a second. From relevant dates, Mainzeal's financial position was so precarious that there were no reasonable grounds for a belief that it could meet the relevant obligations when due. There were basically two categories of obligations in that regard, which formed the basis of the breach and the ultimate compensation that was ordered, which I'll come to shortly. Ultimately, the directors were held liable to pay $39.8 million compensation for breach of Section 136. That amount was after a reduction. That compensation order was reduced for some of the directors who were found to be less culpable, because the court, under the New Zealand provisions, has some discretion in that regard. The topic of assessing damages was a key and complex issue.
If I can just jump in very briefly for 1 second there, I've seen in the Q&A that Jim sort of referenced letters of comfort and whether or not the letter of comfort would potentially be enough on the facts of this case. That's probably a whole potentially other seminar in itself in respect of the letter of comfort issue. One of the things that factually on this case was the way in which that comfort was provided, and there were letters of comfort. There's a lot of discussion in the judgment as to whether or not there's a contractually enforceable obligation as between the parent company and the New Zealand subsidiary. And the court did put a lot of stock in that at no point was there a contractually enforceable obligation. And that sort of is examined in various ways. For the purposes of this case and this fact scenario, I guess you could say a traditional letter of comfort was not enough when you take account of the full set of circumstances that was at play here, with continual assertions of comfort and then things, not actually being able to get money out of the parent company in China, and the practicalities that were at play. So, that in some circumstances, maybe depending on the terms of the letter of comfort and how it plays out, it'll always be fact specific, but it wasn't enough here.
I'd just add, that there's a history of problems here with this company, and the court recognised that they'd been basically balance sheet insolvent for several years. I think they'd only made a profit once or twice out of about 8 or so years. And so I guess the spin that I would add to that is, well, a letter of comfort might be enough if the related entities are also actually providing support.
If they're actually doing it.
It wasn't enough when they stopped providing that support and they realised, oh, of course, it's not legally binding. So it's relevant while support is being provided, but it runs out at some point. The Australian case that comes to mind, although it didn't involve letter of comfort, was that international cat case in the Queensland Court of Appeal, where kind of major stakeholder is actually paying the debts. Now, they didn't have a legal obligation to do that, but they did it over a long period of time, and the court there said that they could rely on that.
And I think, Jason, I'm glad you raised that, because I think that point in that case went to the insolvency test, I think, which is, there was a point I was going to make later when I talk about the fact that the insolvency test, looking at our Section 95A, does not loom large in the New Zealand provisions. It's not an element that needs to be proven. And I've often asked myself, well, how does the case law, our Section 95A case law on financial support and degree of assuredness, I think International Cat also involved a related party loan that was able to be called up on demand, which is usually taken to be part of the test, but the court said, look, it was never going to be called up because it was a related party. It was the director's basically his call to call it up or not, and he was never going to do that. How does all that case law compare to the New Zealand Supreme Court's approach to the issue of reckless trading, that is, pressing those concerns to a logical conclusion? Did you get to the same result, or can you get, do you have differences? I think that's something that I've been thinking about, whether what I call the degree of assuredness test under our Section 95A in terms of financial support is the same as, the requirement to have a binding commitment from your related parties to put you in the clear in New Zealand from Section 135. I'm not sure necessarily that it's the same, but it's an interesting point to ponder.
Just to add a further point to that, one of the interesting things I found in reading the case was the point that they made about the directors not actively going out and seeking external advice. And there was that point where they basically said, at the relevant time, if you've gone off and got independent legal advice, they would have been likely to tell you, these things are not binding. You can't rely on these things.
Yes.
Yeah, sort of a little bit of an almost flavour of willful blindness. They didn't ask the right questions at the right time, and in the factual context, it sort of did them in the end. But I think that point on insolvency is a really interesting one too, and how much more potentially complicated or difficult may the Mainzeal decision been if all those issues around a 95 capital A test were also at play under the New Zealand law. I think that's really interesting.
I was sort of holding back a little bit because I wanted to touch on this later.
I think we're going to get to that a bit later on.
Bring it out now, but I'm glad Jason mentioned that case and that issue. But what I mean by the degree of assuredness test under Section 95A is that there's a history of some money coming in from other group entities, and there's a history of support in real money at times. The fact that there's no financially binding commitment doesn't mean necessarily that it's not a resource that can make you solve. So the resource doesn't have to be a financially binding commitment necessarily under Section 95A, whereas here, the New Zealand Supreme Court in the Mainzeal said, it carried a lot of weight, didn't it, that it wasn't a financially binding commitment. So that's an interesting point of comparison, I think.
Definitely agree with that.
So assessment of damages, this is probably one of the heaviest parts of the judgment to sort of work through. And I think there are some analogous issues that we are confronting or have confronted in Australia in solvent trading cases as well, where liquidators are trying to quantify their claim for insolvent trading, because our provision uses the term loss or damage to creditors. And of course, it's a debt-specific debt-specific duty in Australia, but the compensation usually obtained or recovered by a liquidator is there for all creditors, which has always been a bit of an interesting disconnect, that to me anyway, with the way our provision and duty works. But getting back to Mainzeal, I'll try and restrain myself from making comparisons just yet as we go. I just want to get the case sort of clear in our minds before we talk about the comparative aspects. Might be better. The assessment, or the quantification of the damages was a key issue, and there were three options open. The court stated to assess the appropriate compensation under sections 135 and 136. There's the net deterioration approach, which is the extent, if any, that the financial position of Mainzeal deteriorated between the date of the breach and the date of liquidation. There's the new debt approach, which is the gross amount of debt that was taken on in breach and remained unpaid at the date of liquidation. Third approach, which really sort of went nowhere ultimately, was the entire deficiency approach, which is the total amount of the unpaid debt on liquidation. So the court held that different approaches applied to the two sections. In terms of section 135, the net deterioration approach applied. That's the extent, if any, that the financial position of the company deteriorated between date of breach and date of liquidation. Now, ultimately, however, the court held that the liquidator had not proven the extent that the financial position of the company had deteriorated, and so no compensation was ordered under for the breach of section 135. So there was a breach, but no remedy. For section 136, the court endorsed the new debt approach, the gross amount of the debt that was taken on in breach and remained unpaid at the date of liquidation. As I mentioned earlier, it's a debt-specific provision. The two relevant categories of debts in respect of which section 136 was breached were, firstly, obligations incurred in relation to four major construction projects that the company entered into after a particular date, January 2011. Those projects involved medium and long-term obligations. And secondly, all obligations incurred from 5 July 2012, which is some 6 months before the ultimate external administration, and they were described as short-term obligations. So ultimately, $39.8 million of compensation was ordered for breach of section 136 after reductions for retentions, referable to the construction projects, and likely dividends in the liquidation. So the 39.8 is the final amount after some of those deductions. Now, under section 301 of New Zealand's Act, there's a power of the court to adjust compensation payable by directors according to their respective culpability. So the most culpable director, who was Mr. Yan, was liable for the 39.8 million. The less culpable directors had their liability reduced to 6.6 million. So getting to, I think, so now some of the key takeaways, helpfully, and I think Natasha mentioned this at the outset, as well as going through some of the policy considerations, the Supreme Court had a very proactive approach to set out some practical guidance for directors, given the importance of the issues in play. So it set out in part of the judgment implications for directors in the future of our judgment. And so firstly, I'm quoting from the judgment. Unsurprisingly, the court stated long-term strategy of trading whilst balance sheet insolvent is generally not acceptable. Judges will allow reasonable time for directors to assess risk, review options, decide what course to take, including time to take advice, point Jason mentioned earlier, and will recognise and adjust for the danger of hindsight bias. I'm sure I've seen that term in an Australian case in the past. I'm not sure of it, Justice Palmer. These concepts are not unfamiliar to us in Australia, of course. Lastly, although directors will not normally be liable for continuing to trade during the taking stock period, that may not be the case if substantial new obligations are taken on without measures in place to allow them to be met. This slide sets out what from my perspective, we've all got different perspectives, which is the joy of these sorts of webinars. We'll come to it with our own perspectives. This, for me, was one of the key parts of the judgment in comparing the standard in New Zealand to the standard in Australia. And so the court stated that we are of the view that the Section 135 standard proceeds, at least in part, on the premise that it is undesirable for a company to trade on in circumstances in which those who deal with it in the future are exposed to substantial risk of serious loss. This, irrespective of the benefit trading on may confer on existing creditors. Having said that, we accept that the directors of an insolvent or nearly insolvent company are entitled to that taking stock period and to obtain a period to obtain advice. So that, for reasons I'll explain now, I think, raises some interesting points of comparison with the Australian provision. So, tongue in cheek, using a little bit of a sporting metaphor here, and of course, none of the Australians participating tonight want to go anywhere near rugby or the Rugby World Cup. We do perhaps want to get into Cricket World Cup territory. I decided to be neutral and try and use soccer as the sporting metaphor to throw up a few points of comparison, which of the jurisdictions has something to learn from the other. So we're obviously comparing reckless insolvent trading in New Zealand with insolvent trading and safe harbour in Australia. So firstly, I'm going to award the opening goal to Australia. I take the view that in deciding whether to trade on, and this is coming from the perspective, and it's one which sometimes, as Jason and Natasha know, I think is a little bit overdone, the turnaround narrative, but I'm going to give that narrative the benefit of the doubt here. And so I think directors do have, I think, more room to move in Australia than under the New Zealand Section 135 standard. And by that, I mean that I read these provisions as the Supreme Court has explained them in New Zealand, as putting directors in New Zealand under a more stringent duty to prevent substantial risk of serious loss to creditors, albeit with that taking stock period. I think Australia's safe harbour has a more forgiving test, of course, with that test of reasonably likely to lead to a better outcome for the company. The term reasonably likely is supported by the generous evidential burden, which is a defined term in our safe harbour provision as well. So to invoke the safe harbour, the director needs to point to reasonable possibility of a reasonable likelihood. Sometimes I profess I'm not quite sure what that means, but I think it seems pretty easy to satisfy.
I think practically that's a really good point to make in the context of comparing the benefits of the safe harbour when we're looking at it in respect of that guidance that was given in Mainzeal, because even that taking stock period, I really understood to be a relatively short temporal period. And what it actually protects is much less than the protections and the flexibility that's given to a board in the context of safe harbour. So yeah, very much agree with that in the context of the turnaround narrative, as you say, and the need to actually get that balance right, that I alluded to at the beginning and is acknowledged in the judgment. I think looking at the taking stock period versus our safe harbour under 588 GA, I think it's definitely a better balance struck by safe harbour compared with what New Zealand have in the interpretation that the Supreme Court's given to reckless trading.
Here's a question without notice for both of you, and comparing these two approaches. If directors are in a circumstance where things are looking pretty grim, and they to continue with the sporting analogies, they want to take a Hail Mary pass to roll the dice, see if they can try and pull things out of the fire. Do either of these approaches offer protection for that, or do we think that courts, if and when they actually consider the safe harbour in Australia, would say, well, the problem with that is it wasn't reasonably likely to lead to a better outcome. It could have led to a better outcome if it worked, but at the time it wasn't reasonably likely to lead to a better outcome. I would have thought that, from what you're saying, Mark, the New Zealand approach would not appear to support that.
I would agree.
I'd agree that the New Zealand one, I don't think would support that kind of Hail Mary, let's see how it goes. I think there is potentially scope that, depending on how your safe harbour period has run, how it's developed, how well it is recorded and sort of implemented and monitored, and providing you're always sort of meeting those tests and weighing up all the options, I think there is probably scope that you would be able to have a situation where, yes, it's the Hail Mary, it's the last ditch big effort. But I think that there are circumstances when you can see how that would still fall on the right side of reasonably likely. So it's always going to be fact specific from the Australian safe harbour perspective. And again, that's going to depend on the quality of your safe harbour advisor and the way that it's all sort of put in place. And it's all untested at the moment. But I definitely think there are circumstances where even that Hail Mary approach would still fall on the right side of the line from a board protection perspective under the safe harbour regime.
I think that's right. And it actually goes very much, Jason, to the point I've put up there on the slide now, the very next slide. And I've deliberately replaced reasonably likely with fair chance. And that phrase is taken from the explanatory memorandum and was referred to in the Safe Harbour Review Report. The Safe Harbour Review Report actually noted that from some commentators, some submitters to the review process, there was a view expressed that unhelpfully, directors take the view that reasonably likely means more likely than not. It actually doesn't mean more likely than not. It just means a fair chance. And so that's, I think, another way of making the same point Natasha did. I think, I mean, there's Hail Marys and there's Hail Marys. If the Hail Mary is, we're talking about risk taking. I think it's a really important point. It's a point on that slide that I really wanted to emphasize tonight. I think, as Natasha says, Safe Harbour does endorse risk taking. Your Safe Harbour plan does not have to, on the balance probabilities, be likely to succeed. It just has to have a more than remote chance of succeeding, a fair chance. And so, I agree with you, Jason, that's not what's permissible in New Zealand. As I put there on the slide, the New Zealand director in that precarious, where the company's in that precarious financial position, can take stock, but then needs to implement measures that remove the substantial risk or cease trading. And I think also this issue comes into sharpest relief when we're looking at future creditors. And it's a point that the New Zealand Supreme Court emphasised in Mainzeal, that you're not entitled to take the punt and put new creditors at risk for the benefit of the collective. That's not permissible in New Zealand. In Australia, under the Safe Harbour,
Arguably it is.
I think it is. And there's that point. There's a future creditor point. And there's also the slightly more subtle point, which wasn't at the center of Mainzeal, but it's this, that when you're just looking at existing creditors, if you, as you said, Jason, you're putting up a Hail Mary or putting in place a plan of sorts that, for instance, might have a fair chance, so it's not more likely than not to succeed, but there's a fair chance it will succeed, of reducing the deficit for all creditors, improving the outcome for all creditors. And that could mean, as I said, reducing the deficit with a view to still a liquidation. Of course, Safe Harbour refers to better outcome than an immediate liquidation.
Yeah.
If that's the plan, you're taking a risk, but you're taking a risk that it doesn't work and that existing creditors go backwards. So there's not just the future creditors' perspective. I think there's the existing creditors. Well, there's always a risk, isn't there, that creditors are actually going to be worse off if you're taking something of a risk. So I think, again, as Natasha said, I agree that our Safe Harbour endorses risk taking. I think final way of making the point would be this. I think in New Zealand, where the focus is on removing substantial risk, in Australia, it's actually the fact that it's actually the case that you can have, as long as you've got a fair chance of success, you can put creditors at substantial risk. That's my view. And we can decide whether that is actually a goal for Australia or should it have been a goal for New Zealand.
Or should have been a goal for New Zealand. Yeah, I think it can be looked at in both ways.
The turnaround narrative, the benefit of the doubt. And we can maybe come back to that point at the end, because I think that's an interesting debate.
Well, I think that's also an interesting debate in the context of the broader general duty, which I think we'll talk about a little bit more as well. The
second point, there's sort of 3 points that I had in terms of comparison. This is what I describe as the equaliser for New Zealand, and Natasha and Jason are well aware of my views on some of these points. No Section 95A issues in the New Zealand provision. So the New Zealand framework, we touched on this earlier, avoids this complexity that we have in Australia, which I am coming to the view that Section 95A is a real problem in our system. That's the view that I'm coming to. I think it's actually more of a problem than sometimes we're aware of. The New Zealand framework certainly avoids all that complexity of having to prove technical actual insolvency at the material time to trigger the duty. So there's that issue about the burden, the cost, the complexity. I promised Natasha I wouldn't talk about the Arium New South Wales Court of Appeal decision, so I won't. But there are, I think, some concerning judgments and complexities in the case law whereby it's become harder and harder for liquidators to prove insolvency, or insolvency is being denied until it's sort of a foot in front of our face. That's one point.
And I think the mental gymnastics and to a large extent potentially the wasted resources that go in to decisions where it is contested as such a, and it obviously is an important issue in the way that our sections are predicated and built. You know, are they set up in a way that we're actually wasting resources on 95A issues? I think that's a really important factor to think about in the bigger picture of you know, where are we going with the regime more generally.
Yeah, and certainly the New Zealand provisions focus more efficiently and directly on problematic behaviour. They're not, I think, distracted by this fixation with the cash flow test for insolvency, with all the issues, financial support, different standards of proof for long-term debts, and the like. So there's that issue. I think also another really important issue to consider as we look ahead to law reform is when do we think these duties should be triggered? Certainly under the New Zealand system, their duties are triggered earlier. Again, because there's no connection to insolvency. Of course, our insolvent trading duty is only triggered when the company is actually insolvent. So I think this extension of the point you just made, Natasha, as well is, you know, I read the judgment and I wondered how would our courts have applied the insolvency test on a cash flow basis to Mainzeal, which traded whilst balance sheet insolvent for years. I think it was 5 years.
Of about 5 years, yeah.
How would our sections have applied if the same facts arose here? Being a bit provocative here, would the company have been treated as solvent on a cash flow basis until the final collapse? And so there wouldn't have been any relevant breaches until the final period. Perhaps part of the Section 136 claim would have also been upheld here, but perhaps not all of the breaches. So, and of course, we've got, as part of the complexity of our insolvency test is the timing. You know, exactly when is the company actually insolvent? I think New Zealand has a much more elegant framework in not sort of cutting through and just not even going there. It doesn't even need to deal with that issue. It just focuses, as I said, on the problematic behaviour and conduct, rather than agonising on the exact date at which, you know, the magical date at which the company was actually insolvent, which we seem to have spent a lot of time on here, notwithstanding that 6 months later, when the company's in liquidation, creditors get nothing, which I find always a bit of an oddity of our system.
What was it all for?
Yeah, so there's that, and so I'll pick up the pace a bit, so I'm conscious of the time. Second goal to New Zealand, so third point of comparison, which I think puts New Zealand ahead 2-1 here. And it's an issue I've written about just this year in an Insolvency Law Journal article. The New Zealand statutory duties are not limited to debts incurred by an insolvent company. Section 135 focuses on a manner of trading. Section 136 in New Zealand focuses on obligations or liabilities. Our insolvent trading duty, of course, is fixated not only on insolvency, but on debts incurred by insolvent companies. That means some types of liabilities or obligations incurred by companies which are deeply insolvent are not even caught by the insolvent trading duty because they're not debts properly so called, or strictly speaking, like contingent unliquidated damages claims for upfront payments, say, paid to an insolvent builder. An example of that was reported recently in an ABC News article. So gift cards is another. It's counterintuitive, but some of these obligations incurred by companies are not actually debts. So, you know, we can talk about what the general law duties might do to help, but certainly 588G is narrower than I think people understand at times. I think our statutory insolvent trading duty is deficient in some technical aspects, which is something of an oddity, again, when you put it alongside the whole safe harbour narrative. I think actually, as I've written this year, an opportunity was lost to not only introduce the safe harbour reform, which I think is a good reform, but to also tighten up the duty itself. And that's a point that was made in the Safe Harbour Review report. And
perhaps we get that back in the context of a comprehensive review as and when that may occur.
Yeah, I think so. Not suggesting any of these things are a panacea or a silver bullet, but enforcement, of course, is interesting. But enforcement, of course, is important. But, hey,
and interesting. I agree.
It would nice to have these sort of egregious obligations that are incurred, you know, a minute before midnight to actually contravene the provision. I mean, I think that would be a good start.
Yeah.
So I might hand over to Natasha now to lead.
I'll just spend a little bit of time touching on a couple of issues in relation to the general duty. And as Mike sort of highlights, we got to our score of sort of 2-1 in favour of New Zealand on that kind of ready reckoner and sports analogy. which kind of leaves us in the context of sort of what else is there and what other factors need to be assessed and what other options are available. And this, again, I think was really well highlighted in the Mainzeal decision and also Sequana, which I'll come to, because in that context of assessing the legal history and the basis for protection of creditor interests under the New Zealand law, they also talked about how a consideration of the effectiveness of a statutory reckless trading provision, or in our case, an insolvent trading regime, also needs to be assessed within the context of the broader director's duties. So as Mark noted for Section 137 and similar in New Zealand. So in that sense, we've also got to look at the general law position, which we've now got to and had in Australia for some time, the well-established general law principle that the director's duty to act in the best interest of the company will, in certain circumstances, require the directors to consider the interests of the creditors. And those circumstances are where the company is nearing insolvency, of doubtful insolvency, or where there is a real and not remote risk of insolvency. So I think everyone, as everyone on this and interested in this issue is sort of aware of and in generally furious agreement that there is this creditor duty, the creditor's duty. It's not owed to them directly, but it is an obligation for the board to take into account creditors' interests and the impacts of the board's decision on creditors as a stakeholder when they're assessing what's in the best interest of the company. And there's a lot to be said around how that works and what the detail of that is. So yes, we've all agreed that it exists, and we've got lots of case law, Walker and Wimborne and Bell, obviously more recently, well established that the duty does exist, but then talking about exactly when it's triggered and what its content is becomes a lot more woolly. And I think there is potential, and one of the useful things to look at if we assess the insolvent trading regime by reference to some of those sort of deficiencies or problems that Mark's identified in that sort of tally. Are we at a point now where the general law duty to consider creditors' interests is developing to such a state where it is available as a standalone remedy to cover the earlier period, and how might an Australian court look at and consider the scope of that general duty in the here and now? And I think we did sort of have the potential that we might have heard from the High Court on that in relation to the Dick Smith proceedings in Potts and DSHE Holdings. But my understanding of that is that that aspect of the decision has now been resolved, and we probably won't get a judgment from the High Court on that, but they are still looking at the misleading, deceptive sort of references in facility agreements, more on the banking side. But for now, it's clear that the content of the creditor's duty in Australia, we look to what Justice Bell said, what Justice Owen said in Bell, and sort of Walker and Wimborne and the various case law that sort of set out. I think termite resources is another one. We've sort of chatted around a lot of the case law that we have. From my perspective, I think it would be worthwhile pleading, in addition to your Section 588G insolvent trading claim from a liquidator perspective, a separate standalone allegation of breach. Obviously, always going to depend on your fact scenario, but making sure that you are including those breach of general law, breach of 180 and 181 under the Corps Act to potentially cover the field and broaden that sort of scope for recovery. But there is a degree of uncertainty, and that's not ideal, because it also then creates uncertainty for directors in the sense of having the benefit of knowing what they can and can't do when the company is in this precarious position. Because obviously the directors also need to bear in mind that safe harbour protection is not going to bite in respect of general law duties and their statutory duties. So yeah, that's also very interesting. And Jason's just sort of noted there, the Mainzeal decision in itself has a really interesting and useful discussion of where the UK Supreme Court got in the Sequana decision from about sort of 12 months or so ago now. And I just wanted to touch on that briefly, which I think we've got in the next slide, Mark. Obviously, I think most people are aware of the Sequana decision, which I guess from one perspective was quite important, particularly from a UK point of view, because it was the case in which the UK Supreme Court did acknowledge that, yes, there is this actual general law duty to take into account and consider the interests of creditors. And what the three questions it looked at is there such a duty? When is it triggered? And what is its content? And the Supreme Court sort of gave guidance on all of those, and thankfully looked at a lot of the Australian case law and said, yes, we agree there is a duty. They didn't necessarily agree at the point in which it's triggered. And that was sort of referable, and I guess part of their decision to trigger the duty at a later stage than I think where it would sit under Australian law at the moment is referable to the fact that they're interpreting that general law duty by reference to the wrongful trading provision in section 214, which we'll touch on shortly in the broader comparison. So we've got this real spectrum now across a whole raft of jurisdictions with a recognition of this general law duty, but a bit of disagreement around where it's triggered and still some uncertainty around its content. And one of the ones that I've just pointed at in the context of Sequana, and obviously we could have had a whole session on that in and of itself, there was a decision of Justice Zaccaroli from July of this year, which actually looked at the decision in Sequana and applied it in a slightly different and broader context. And it's a relatively short decision, and one that I would definitely sort of encourage people to have a look at, because it's really interesting, because Justice Zaccaroli, like the court in that case in Hunt and Singh, pushes the envelope a little bit further than what the Supreme Court appears to have done in Sequana itself. And that was justified on the basis of the fact scenario being different in circumstances where there was, in Hunt and Singh, the company was insolvent, and the main point of difference and the main reason in which it sort of continued to trade is there was an argument over tax liabilities owed to the UK tax office, where they'd set up a scheme. If the scheme was valid, the tax liabilities wouldn't exist. But if it wasn't valid, they were absolutely horrendously underwater, which is not an unusual situation. I think there's been a number of cases that have been similar to that in the past. And what ultimately came down in that case is the court recognised that in those circumstances, they did start to adopt that sort of more real risk wording and move away from the bordering on insolvency element, that moving away from irretrievably insolvent as the trigger point. So it is a really interesting one. I don't want to spend too much more time focusing on that, but I think it's definitely worth a read. And yeah, there's a few sort of interesting aspects of that judgment. And one of the ones I'll just quickly quote from, and this is from paragraph 59 in that judgment, but it was acknowledged that identifying where on the sliding scale between high probability of success and high probability of failure, the duty to consider interests of creditors cuts in is inherently difficult. And that's really going to always be the challenge and be one of the reasons why this is always going to be a very fact-specific analysis. But yeah, by all means, have a look at that decision, because I think it's also a really useful and interesting gloss on some of the things that we've discussed in the context of Mainzeil. The other thing we just briefly did, and again, we can kind of look at this in more detail if we had all the time in the world, is to sort of put together a little bit of a comparison or spectrum on where these provisions sit in terms of most creditor friendly to least creditor friendly, or degrees of flexibility within them. And at the moment, we've sort of made the call to put Australia pretty much in the middle, which I think most people would agree with. I'd be happy to hear otherwise. But section 135 reckless trading, as Mark's discussed in the context of Mainzeil, we've got very useful guidance from the New Zealand Supreme Court as to when it bites, and that's great to have that, but it is quite blunt. The Australian Safe Harbour provision and the protections that it gives in the context of some of the flawed elements of insolvent trading, I think we're getting some things right, but perhaps not all of them. And then the question in terms of the UK, which is sort of, it's more of a focus on fraudulent or wrongful trading. So it will kick in later down the spectrum, which has the benefit of perhaps being more turnaround friendly, to sort of use that relatively, I guess, sometimes simplistic approach to it. But these are the sort of things that I guess we can take the opportunity to look from a reform context and say, well, what other pieces of the regimes across these particular provisions? We're obviously looking at one tiny little piece of it, but in the context of assessing the benefits and where we want that balance to lie, what tweaks can we potentially make to our insolvent trading provisions and safe harbour protections? And then what other mechanisms might we want to also look at in a similar way in terms of providing that greater balance for turnaround and business judgment and bringing a focus on financial distress earlier, as opposed to absolutely prioritising and and making paramount the creditor's interests. So, really seeking to illustrate the things that we have to consider and the differing perspectives that are at play.
Can I just add a quick thing there? I think it's interesting in this context. I don't disagree with anything you've said there, Natasha. I think that's probably right in terms of the spectrum of these provisions on these provisions. But I think it'd be interesting for us as a practical matter to then think about, well, where do the duties to act in the best interest of the company in the context of creditors,
where do they start lining up? And I think if I had more time, we could maybe turn this into a sort of more detailed timeline and to sort of do it, maybe visualize where, according to various authorities, these things start to kick in, and are we getting the settings right?
Yeah, and that's where the lack of a comprehensive review really shows the weaknesses in the system. Because it may well be, I'm not saying this personally, I think insolvent trading should be abolished, but it may be that we've got the policy settings right now with insolvent trading and safe harbour in terms of giving enough flexibility. That might be the case, but is it still the case? Well, okay, you comply with the safe harbour, but then you can still get sued for breaching the duty of care. You can still get sued for failing to take into account the interests of creditors. So,
and is that something that we want in terms of having a degree of flexibility? Because it's so hard to get a one size fits all. Like it's a specific insolvent trading provision is at some point always going to be a little bit blunt. Like you need to have parameters around it. So you have the flexibility of a backup in terms of the general law duty and sort of equity coming to assistance, I guess.
I recall, I'm sure I recall in a RETA forum following the release of the review of the safe harbour, and the chair of the panel that conducted the review, Genevieve Sexton, made the point that with our insolvent trading duty now with safe harbour, we have something that's pretty actually close to Section 214 of the UK. It's just that we need 4 pages of legislation to provide for it instead of a few paragraphs, which I appreciate that observation more. The more I look at the detail and think through the various scenarios, I think thinking through again that test for safe harbour protection being a fair chance of success, when your chance of success is remote or fanciful, I think you are pretty much in 214 UK territory where an insolvent liquidation is inevitable. So, and I think that goes into sort of Jason's point that we may well have the policy settings right. We sort of know what we want, but goodness, it's a
convoluted way to get there.
And as Jason correctly identifies, we've got all these other duties as well which overlap. I think I agree with Jason's point about the comprehensive review hopefully being able to address that. I'm not sure flexibility is everything, and for what it's worth, my view's long been that we bring forward the trigger for the duties. However we do that, I know the definition of financial distress is probably not well, it's probably easier said than done, but it doesn't mean companies shut down early. It's not anti-restructuring. It's just bringing forward the trigger of the duties, which will actually I think, add to the stick that we need as well as the carrot, so that directors are doing all the reasonable things we expect of them. They're just going to be prompted to do it earlier.
A little bit earlier.
That's my view.
Yeah, I'm not sure I'm quite ready to let go of some form of insolvent trading. I think the stick is quite powerful from a behavioural perspective, but I don't think it necessarily works as well as it could or should. And I think there's definitely more elegant and efficient and clearer for directors ways to do it. And I think that's, we do have I know we're sort of pushing on 7 now, but we do have a sort of slide with a few comments and thoughts around opportunities for reform in Australia. And I think from my perspective, really embracing and taking advantage of the pregnant potential we still have for a comprehensive review. It'll be good once we've got a little bit more certainty that it will occur. But really having the opportunity to look at and assess in a broad context of where we are now, what do we want to achieve out of the system? How can we achieve that balance? What can we take from a best of breed perspective? And that's not just limited to things like the stick of insolvent trading, but it's what other things do we need to do, potentially additional mechanisms like a DIP funding regime to resolve some of those robbing Peter to pay Paul type challenges that can occur when directors might be turning around or seeking to turn around a financially distressed entity. So there's definitely going to be lots to talk about, and I think there were some really useful points in the comments around toothless tiger, or what other sorts of things can we do? And I think we're in a really lovely opportunity now at this point to sort of draw on the views from both an academic and practice driven perspective to work out how can we do it better.
Yeah, agree. And get that slide there. I've skipped over one slide, which was a point about some issues for potential law reform in New Zealand, which we've run out of time to deal with, but it basically goes to the sort of the remedy mechanics of reckless trading or Section 136 claims in New Zealand. So we don't have time to go into that in depth, and I think it'd be better with the little time we've got left just to draw a line under that discussion about potential reform, and just noting that the PJC inquiry report did recommend that the government forthwith implement the recommendations of the Safe Harbour Review Report, which is a great piece of work which has been sitting there. There was a government response prior to the change of government, picking up some of the recommendations, not all of them. Some of them were noted. And I think that's obviously an important piece at the moment. It's something that many submitters to the inquiry, I think including Arita, stated that submitted that we don't need comprehensive review to start picking some of this low-hanging fruit and getting these quick fixes done. There's a lot of good work that went into that report, and so I've wherever I have an opportunity, I want to emphasise the quality of the work in the Safe Harbour Review Report, and it's still a great reference for people to go back to, and made some great recommendations about making the Safe Harbour work even better. In terms of just final point I probably make, and it's a big idea, I think, just to throw into the mix about thinking about how to design a system that strikes the right balance. And it goes to the point I've been making in some of my writing recently in the Insolvency Law Journal article this year about automatic banning of directors and holding directors accountable for outcomes. Maybe I think something that could be focused on a little bit more in looking at how we calibrate our system. So if we're going to give directors the leeway, the accommodative settings, and it doesn't work out, maybe, or if they don't behave reasonably, and we end up with what we have now, which is most liquidations returning nothing, should there be an automatic consequence for that balance sheet outcome? So again, a system that, rather than sort of focusing on the conduct and whether it's met the standard or not, and going through all the history and the proof and the standards and all the complexities we've been discussing tonight, is there maybe a simpler way where directors are held more accountable for outcomes? And so, for instance, if in the event of minimal returns twice or 3 times, you're automatically banned for a few months. We have very low numbers of disqualifications.
Automatic bannings.
That's just one idea.
That mechanism is there, and is it
Yeah.
used enough? And I know there's definitely been some, and I think Robin Bowley did something looking at 206 capital F orders quite some time ago. And we know ASIC still uses them, but you know, is there different ways in which that can be accessed or utilised? And then again, we sort of touched on briefly the enforcement element as well, which is an important piece of the picture to not lose track on. You know, whatever we get, we need to be ensuring that they are laws that are capable of efficient and effective application and enforcement, so that they actually do, you know, they do have bite, and they do bring about the behavioural recognition and changes that need to occur.
Okay, I'm just mindful of the time. We did have some questions along the way where I've typed an answer to those questions. So I think we should draw it to a close because we've just ticked over the 7 o'clock mark. Thanks everyone for giving up your time tonight, and thanks for the questions that were posted during the discussion. And thanks, of course, to Mark and Natasha for sharing your thoughts on this very interesting issue. And, you know, let's keep the conversation going. Certainly, if we have a general broader review coming into place in the future, then there'll be further room to ventilate these issues. So as I said right at the start, this session's being recorded, so you'll receive a link to the YouTube recording of this, as well as a copy of Natasha and Mark's slides. So thanks everyone, and enjoy the rest of your evening.
Thanks, Jason. Thanks, Tash.
Thanks everyone.
The opportunity.